Hello everyone, welcome back to the channel Contract Simplified. In today's fast-paced business environment, safeguarding confidential information, that is CIs, and intellectual property rights IPR is a top priority. Many organizations rely on non-disclosure agreement NDAs to protect sensitive information during discussions and collaborations. However, a common question arises. If IP is shared under an NDA, does that constitute licensing? Understand this better, let us first understand what do you mean by confidential information and what do you mean by intellectual property. So, CIs, that is confidential information, refers to proprietary data, trade secrets, business strategies, financials, client list, and other sensitive details that an entity seeks to protect from unauthorized disclosure. On the other hand, intellectual property includes patent, copyright, trademark, trade secrets, and proprietary technology. Unlike CI, IP can be formally protected through registration and grants certain exclusive rights to the owner. Now let us come to the main question, and that is, does sharing IP under an NDA imply licensing? The short answer is no. Sharing IP under an NDA does not automatically mean licensing. Here is why. First one, nature of an NDA. NDA is primarily designed to restrict the disclosure and misuse of confidential information shared between parties. It sets forth obligations regarding confidentiality, but does not typically include provisions granting the recipient rights to use, modify, distribute, or commercially exploit the IP. Second, distinction between NDA and license agreement. A licensing agreement explicitly grants permission to use IP under specific terms and conditions, such as scope of use, example, commercial or non commercial use, duration of use, royalties or fees if applicable, territory of use, modification, and distribution right. NDA, on the other hand, does not inherently provide such permission. It merely protects the disclosed information from unauthorized use or sharing. Third, risk of implicit licensing. If an NDA is not carefully drafted, it might inadvertently create an implied license where the recipient believes they have the right to use the disclosed IP beyond the confidentiality obligations. To avoid such an ambiguity, an NDA should explicitly state no rights or license to the disclosed information are granted under this agreement. The disclosure of IPs is for evaluation purpose only and does not permit its use, reproduction, or distribution. Now, let us move to the best practices to avoid licensing ambiguity in NDAs. Firstly, clearly define the purpose. Specify that IP is being shared strictly for evaluation or discussion purpose. Second, explicitly exclude license grant. Include a clause stating that no rights or licenses are transferable by disclosure. Third, restrict the use of disclosed IP. Clearly limit usage to internal review and prohibit reproduction, distribution, or commercial exploitation. Fourth, include ownership clause. Reaffirm that the disclosing party retains all ownership and rights to its IP. Last but not the least, draft a separate licensing agreement if necessary. If usage rights needs to be granted, execute a distinct license agreement to avoid confusion. Now, let us look at the key clauses to include in an NDA while sharing IP. The first one and the most important one is no license grant clause. The disclosing party retains all right, title, and interest in and to its intellectual property. Nothing in this agreement shall be construed as granting the receiving party any rights by license or otherwise to use, copy, distribute, or modify the disclosing party's intellectual property except as expressly permitted in writing. The receiving party acknowledges that all intellectual property remains the exclusive property of disclosing property. In addition to this, clauses like permitted use clause, no reverse engineering clause, no use and non-disclosure clause, residuals clause, and return or destruction of materials clause can be added to support this clause. While NDAs are crucial for safeguarding confidential information and intellectual property, they do not inherently grant IP licenses. Business must be cautious in drafting NDAs to prevent any unintentional transfer of rights and should implement clear constitutional safeguard. This is all for today, and I hope you found this video useful. If yes, do share it with your friends. Do let me know in the comment section. And also, if you have any suggestions for the topic, I'm very much open for this one. That's all, and yeah, I'll see you in the next video.